Okay, 6:30 PM on June 20th, right? 20?
Yep.
20th, 2024, meeting of the ZBA. This meeting is being recorded. If any other persons present are doing the same, you must notify the chairperson at this time. In accordance with Mass General Laws, Chapter 30A, Section 20, subsection G, no person shall address a meeting of a public body without permission of the chair, and I am the chair. Signs aren't here, but I'm the chair. And all persons shall, at the request of the chair, be silent. No person shall disrupt the proceedings of a meeting of a public body. If after clear warning from the chair, person continues to disrupt the proceedings, the chair may order the person to withdraw from the meeting. And if the person does not withdraw, the chair may authorize a constable or other officer to remove the person from the meeting. Mr. Clerk, would you please read the application or hearing that's before us?
This is a continuation from the May 30th meeting, application of Stephanie Duclos for property located at 6 Arch Street, Assessor's Tax Map 64, Lot 18, which is located in the Central Commercial CC zoning district for appeal for the building permit issued by Mark Snow, Inspector of Buildings, dated March 26, 2024.
Okay, so Eric, I believe we left the hearing still open, correct?
Correct.
So members of the board, do we feel like we need or want to take more testimony? Do we want to have people sort of sum up what they want to do? And then I think tonight I would like us to deliberate. So, if you think we need any more, or in fairness to the applicants, let them speak a little bit. What do you think?
I'm open to it.
Have an opinion?
Unless somebody has something specific to add other than what's already been provided to us, I don't have it. I would not feel the need
I-
for additional.
believe we heard enough a couple of weeks.
I'm in agreement with Debbie.
Hold on a second, Stephanie. So, okay, so now I'll recognize you. Yes.
There's an additional aggrieved party present that would like the opportunity to speak. That he did not find out about the meeting, the hearing prior through proper notice. He's an affected party with civil litigation. And he came to the city hall today to ask if he could get this meeting as an affected party.
Okay, I'll consider that. Anybody else want to speak? Anybody from CSO? Okay. Al, are you the person?
Yes.
All right, would you come up to the chair, please? I will give you, and I don't mean to be disrespectful, I'll give you 5 minutes.
It's fine.
That should be enough. I've read your material.
Hi, Mel Constant.
Al, go ahead. Identify yourself, yep.
I own 116 Chapman Street, which abuts One Arch Place. I bought that building in 1975 and owned it ever since. And in 1992, I made an agreement with Edward Martin to allow him to take easement on the back of my property, One Arch Place to Chapman Street. He then built a retaining wall and put a driveway in there. That same agreement then was transferred to CSO. Now, the easement is in terrible condition and needs some work. I have approached CSO on it to no avail, and we are now in litigation in Superior Court on it. I have had an engineering study on it, which Stephanie, I believe, had sent forward to you. And in that agreement, it pretty much says it's going to fall down. And I don't believe that it's a good idea whatsoever to put any type of, structure is a bad word, but some type of a meeting room or housing or what have you in there, because the engineer basically says it's a health hazard. And that should be repaired before we do anything to cause more traffic to go down to One Arch Place. Now, there is no sidewalks up and down into there. People just walk through the parking lot, walk down that hill, which is very dangerous in itself. The water goes underneath that pavement and is eroded, and many times it's had to be filled. So in conclusion, that's not the place for this housing project. It really isn't. And it's not safe. It really isn't safe. Now, in his exact words, if you give me a second, he said the wall in its current condition is deteriorated enough that it is considered a public safety hazard. And that was the licensed engineer, which I gave you a copy of it, but it was the engineering group. And his name was John Whaling and license number 46578. Thank you very much.
Thank you. I think we need to hear from the applicant. Anybody else or like close the hearing?
I do have a quick question for Alan, if that's okay. The document that we received from the engineering group, that was dated 11/3/2019, or is there a newer document?
That is the correct document.
Thank you. I just wanted to try the right copy.
I feel this is how I feel personally, that Stephanie has done a good job of giving us all the information that she wants us to see. So I'm not sure how hearing from you in summary form would be that helpful, although I don't mean to be rude to you, but I think we have everything we need in terms of understanding what your concerns are. Now, CSO is on the other side of it. Who's here from CSO? I will give you a chance to say something if you want to say something. I'll give you 10 minutes. Tell me since you're on the other side of the application, of her application to deny the appeal, and we've heard all her stuff. What do you have to say for yourselves before I close the hearing, if anything?
Sam Prickett, attorney for CSO.
Yes, nice to meet you.
Just trying to collect my thoughts so I don't rehash, what we discussed last time.
Take your time.
But I believe at the request of the board, there was a question about 20710 from the last hearing that we
You
didn't.
mean the section of the zoning
Yeah,
ordinance?
the section of the zoning.
For 710B,
You want to comment? You want to
Yeah,
comment on
we
that?
wanted to comment on that that was, I believe that was applicable to wells, but it's not applicable here because there's not the permanent housing going in. And I think there was some confusion around that. That's why it wasn't included in the memo. It's not a mixed residential pursuant to 710.
So you think that you think it implies a permanent condition?
Yes,
And what makes you think that?
the zoning work done, and as explained in the memorandum, the zoning work done around 60 wells, where it said that the use of the property as the shelter falls under the business and professional offices, and it was transformed into the residential because they are putting in the permanent units at 60 wells as part of the project at 60 wells. That's not happening at 6 Arch. 6 Arch is just the business and professional offices as the shelter.
There's no beds in there, or people aren't going to be living there?
People are not going to be living there in a residential sense, such that it would qualify under 710.
But are they gonna be staying there overnight?
Aren't people going to stay overnight? That's right. And eat food there and
shower and
shower and
Use-
learn, be educated?
And as I said,
Wouldn't it be better if we added that to the list rather than said it was, wouldn't it be better if there were 3 things for us to look at rather than 2?
again, this is an appeal. CSO went through this process, asked what sections they needed to.
I know,
comply, and they complied with what they did. I mean, this is Greenfield zoning ordinance. We don't feel that it falls under that residential section, and that's how we feel. If you feel different, I mean, I don't know what to tell you. Based on our research, based on third-party research, based on asking the city through the entire application process, it didn't fall under those things. And thus the application wasn't placed with that in mind for 6 Arch. It was for 60 wells because they were told to do so.
Fair enough.
I believe Ms. Duplo submitted some materials regarding floodplains. I just wanted to submit, I guess, contradictory materials showing that that is not in a floodplain. Printed out.
Has she seen those things?
No.
She has not. I have a copy for her.
Great. I think you had to look at it, so you should look at it.
Yes.
This is the firm map, the flood insurance rate map promulgated by National Flood Insurance Program and FEMA, which shows that the Arch Street location is in zone C. It's an area of no significant risk. It's not in the 100-year or 500-year flood. I have copies for everyone who would like to see.
I would like to look at
The first one is small, so I included a somewhat blown up second page. Here. Awesome. You can knock your file.
I already got it on there, yeah, I know that. My office keeps medicinal firms. Yes, pretty much have it memorized the entire floodplain areas and
Okay, what else?
Other than that, we just, we don't feel like anything has been presented that shows that this needs to be anything other than site plan review, which what took place was approved. Unless the board has any specific questions for us that you would like us to clarify above and beyond the memorandum that we submitted, then
To refresh my memory, how many units are you going in there?
there are no permanent residential units going into 6 Arch.
Okay, how many people will be sleeping there? Yeah,
How many?
45?
I was 40 something.
35, thank you.
The application just.
Yeah, I think
So I have a question for you. Why didn't you submit a full-fledged site plan?
A full-fledged site plan?
Yeah, as the 8.4 requires.
Well, 8.4 requires things that are applicable. And as this is all interior,
That's your opinion.
well, it's our opinion and it's also Mr. Tuareg's opinion, who told
I
them.
understand, but you're also an attorney independent of Mr. Turog.
Mhm.
You really going to tell me that all those things in 8.4 are not applicable?
We can go through them if you like.
I'd love to. What's the point of order? No, sorry, you'll get your turn. Thank you. Okay. You would admit that you are under the jurisdiction of a site plan, correct?
Correct, yeah,
So then let's go to the maybe D.
yeah, that's right. All site plans should be prepared to scale and shall at minimum accurately show the following information if applicable. Start with a locus map. You know
Okay.
where the locus is. The application shows the building.
I don't see anything. Do you have a site plan on you that shows the locus? I have a site plan that shows an interior, shows the framing of the space that's going to be constructed. That's all I have. Is that what the site plan was?
With the address, yes.
Yeah, so I don't consider that a locus map. So
Okay.
fail that test. What else?
Is there a portion of the approval process that would require a locus map for interior work?
Yes, I think that the whole point of the site plan is to demonstrate to planning board and to people who wish to come and see the site plan what's going on the site, how your work there impacts the neighbors, how it impacts water, stream, drainage, flooding, parking. That's why we need a locus map. I mean, to me, looking at your site plan, it could be anywhere on earth.
Okay.
So is this
And
proposed topography, the boundaries of streets, proposed structures, elevation plan, parking, proposed water supply, storm drainage, landscape, location, let's see. Yeah, I think that's enough. Measures to prevent pollution of surface and groundwater runoff. Control measures to prevent erosion. I don't know, I think those things are important. Yes,
May I
sir.
add something for CSO? George Gold, property manager, with Jones with Architects, and I just put up here if I can come forward. As noted, these are the permit plans that were filed. This is a half-size set of the plans that were reviewed by both Eric's office as well as Mark Snow's office. And it does include a locus plan showing the street locations. We coordinated very carefully with,
You're telling me that this was the site plan, or this is?
this was the building permit set of plans.
But that's,
Yeah. But
That's an internal communication.
we did coordinate directly, and we have a record of it, of coordinating directly with Eric's office and asked if there was a need for a site plan, and we were told, because the work is all internal, we to provide it.
Okay.
So in our estimation, as the architect's office, that was acceptable. We felt the work was internal, it did not affect outside grading or drainage.
Then George basically said what I was going to say, is, CSO looked at all these things. They said, okay, these things aren't going to be changed from the current use. We don't think they're necessary. They asked the city what was necessary. They said just the before and after interior plan, which was submitted and approved. If the planning board required any of the rest of these things, CSO would have been more than happy to give them at the time. There's nothing that they're trying to hide. And that's it, unless you have more questions. Thank you.
Stephanie, do you have something you want to ask the board?
Yeah, I did this. Yeah, the date. Is the date July 2nd, 19th, was that the date of what is that?
Correct. It's also the date that is included in the Greenfield zoning ordinance as the map that you use.
We have oversight by FERCog. And we also have a Green River corridor overlay. Especially in areas that are flood prone. I think I submitted more than enough, and I think that anybody who lives in proximity or uses Chapman Wells or Arch knows on a regular basis, it floods and is closed down. Those are obvious observations. They're posted all over. Road closures are just flooded. So I know there is an updated FERCog overlay, Green River overlay, because in our master plan, it very specifically says we actually care about our waterways, the watershed, and the culverts. We even have the Conservation Commission, and no NOI was filed with that. I believe that's procedure. I also wanted to remark that I believe that even if it were to get past the site approval plan, if it were to get all of this, it still wouldn't pass building code. You couldn't ensure the public safety, you couldn't do the open space protections, you couldn't do the parking, it still wouldn't pass for this particular property. I have lived abutting that property for 20 years. As a matter of fact, purchased it off the owners of One Arch Place at the time, Mr. Martin and Ms. Fields. I know the problems with the site. There are pipes that don't necessarily show up on maps, but they most certainly exist in a vault that's here at City Hall. There is infrastructure under there that may not be recognized and not be of concern to anybody who's not living right there and is going to be affected if you trench there in an off time. And then we subsequently have a flood and all of that washes into our groundwater. And again, I'm going to have more trenching in my neighborhood because of the I&I. The site is not appropriate. It would not pass building or health. So I'm asking them to deny this.
I understand. Okay, thank you. Thank you. Okay, I'm going to close the public hearing at 6:49. Okay, who wants to start?
There's been a lot of information shared. But I think we need to go back to, I guess, whether or not CSO has a right to use this space based on the laws that we have written. I understand completely the concerns about the waterways, the impact those additional facilities would have on all of that. But I don't know if that's necessarily the question that's before us, or that we have any authority to change any of those other things other than to view the application, which is an appeal to whether, I mean, the question was that was about whether or not the condition, that everything met the correct procedures. I think is what we're reviewing here,
Mhm.
not whether or not it's going to impact the flood, the water, the floods, all of that. I think it comes down to is, do they have a right to do this? And did they follow the correct procedures? That's what's before us, correct?
Correct.
I just don't want to lose sight of what the part that we play in this.
I think we have two things. And Attorney Quinn gave us kind of the outline. Number one, are they allowed to be there as a matter of right? The applicant says they do not, that they need a special permit. And we have to take a fresh look at what's going on and decide whether or not they do have a right to be there as a matter of right, or they need a special permit. There is a second thing, though. I think that the site plan is part and parcel of the building permit. And the question we have to ask ourselves is not whether everything the applicant says has merit, but whether or not the applicant is stimulated because there wasn't something that was presented to the public showing exactly where these things are that she's concerned about, so that even though the change of use per se, and we could think along these lines, doesn't change anything, the reason for the site plan review is to give the public a chance to see what's going on if such a change is made. So if you get to pass go with permission, because you don't need a special permit, you don't get to pass go again until a proper site plan is presented before the planning board and the public has a chance to see what's going on as well as the planning board itself. Otherwise, why would we have a site plan review in front of the planning board if we could do it administratively? I mean, the building inspector could administratively look at the site plan and say, it's fine. And then the public wouldn't have a chance to participate. The reason for the site plan review is to balance it may be a lot have to do these site plans, but they're done for a reason. And I think the applicant is saying to us, we have to decide whether we all agree on this, that by the process not being followed, I didn't have a right to come and talk about the things that I'm now talking to you all about. Now, it doesn't mean that CSO couldn't present a site plan, locus map, pipes, waterways that then they and the city departments review and say, this passes muster. This is fine. Even though Stephanie is stimulated by all this, the issues that she has are not being caused by this property, or they're not part of the process that we're going through. But that did not happen. So that's where I am with this. I don't want to get into the details. I think that it should go back to the planning board itself for a proper site plan review process. That's that. But before we even get to that, because I think that'll take a longer conversation, I think they have a right to be there. It could be either the Dover Amendment, although I don't think they did an A+ job supporting it, but I think that in general, my experience with Chapter 48, Section 3, they do there, passes the test, all the cases. That's what they want. They want organizations like that to be able to break through the barriers of zoning to put their uses there. I think 710 is relevant, even though it's temporary, there's nothing there, but okay, so, and then the business or professional. So there's 3 different hooks that we can hang our hat on that this place has a right to be there without a special permit. So I just think it's the site plan that we might not all agree. Or might see our roles differently, each of us might see what the role of the ZBA differently in terms of doing stuff.
I've been on the board long enough to see multiple submissions for site plan review. Some that have a checklist of all the things that are on it and say, snow removal, not applicable. Handicap parking, not applicable. So, and it comes in with a detailed list of all the things that are, I think they use this as a matrix to do that. I hope we're not saying that in our opinion, if they say non-applicable, we're going to say it is applicable. Because if that's the case, then that site plan review would confuse me because they're coming in, giving that information. And if the public differs with that, but are you suggesting that we would go through these with a submission and analyze whether in fact our opinion they're applicable or not applicable?
Well,
Because we've had some that have none of that. Okay. They submit it to us. We take it. We don't go through a checklist and we agree to approve it. So what process are we going to use? Make sure that when people come in, take this checklist so we make sure they've done that. Because we've approved a lot that have not followed this methodology of having all these boxes checked. Yet we've approved them.
so what if we had a hearing under your circumstance? And somebody came in and was very upset that the site plan was not thorough and that there were snow removing issues and there were other issues, and that person convinced you that those things should have been on the site plan.
Yeah, but if we're gonna have that process, I understand that. But how do we administer that going forward? Do we do it upon demand? Or should we have the applicants take this form, this process and say, okay, all these things are approved, that have been agreed upon and are not either applicable and they're dealing with them or they're not applicable and we don't have to be. I understand what you're saying, but how do we go forward with someone who, because this was before the planning board. The public had a chance to review this and critique it, and they didn't. So is it not no, I'm just saying it got site plan approval. And I don't see anything in the planning board's commentary about the criteria that was not acceptable as any issue. It's now come before us.
There's a lot of silence in there.
So I'm trying to understand exactly how we move forward. Because in my opinion, from what I've heard from the attorney, they have the right to be there. As Debbie indicated, the process is we've checked it off. If we're now want to go through all of these, sending it back to the planning board, what's going to be different if we send it back to the planning board?
Well, isn't the applicant before us because they are not happy, they disagree with what the planning board decided?
I understand it,
So,
but if we're going to send it back to the planning board, do we want the planning board to have this done all over? Or, we have the authority, I would think, to say, we could go through these as the ZBA and stipulate criteria that needs to be done now. I'm just process-wise trying to understand what we're trying to accomplish.
well, I guess I totally understand where you're going, and in concept, I agree with you. I'm just trying to think, what is, I think that's actually the question on the table. So what is the recourse? The planning board has done their part. They've said, yes, they said, yeah, this is fine. Someone's come forth and said, no, I disagree with that. I don't think this is fine. So now it's before us to determine, well, what do we do with it here? I don't know if that question means we have to alter everything we do going forward. That could be like a subset of the conversation.
But if we go through the site issues that are there and we say, okay, first of all, I don't understand why that's needing to be dealt with, but be that as it may, we send it back to the planning board or have them review it. That means they would have to re-engineer the site to make specific commentary that says this is not applicable to this particular project.
What's
What's being said is the site needs to be completely reviewed because there's stormwater problems, okay? And,
I don't know if necessarily even said that specifically yet.
well, there's flooding on the bottom, for lack of another word, there's a lot of water problems on the site. Sending it back to the planning board, how will they resolve that? Because that's, I think, a major issue. And that's not part of the renovation to the building, I don't think. Or are we going to make it part of that?
Well, the test could be, does the site plan impact the use directly? And if it doesn't, then those things can disappear. Or if there's a change of use, there are two places that we look to see where the public can participate. One is, do they require a special permit? Yes, then they have to come before us. That's a set of criteria over here, right? Then they come for site plan review to us, right? Along with it, another set of criteria for people to review. If it's not a special permit, that's out. Now the site plan is coming before the planning board for a review so that there can be public participation and input, and they could say, wait a minute, look at this site plan. This isn't right. And if they do, then what? If the planning board says you're all wet and we're not going to listen to you, then the person says, well, I'm going to appeal it at the building permit level and bring it to the ZBA and see what they said. And if the ZBA says that the applicant is all wet, then that's the end of it. But if the ZBA says, well, wait a minute, that process wasn't an informative process for such a big project that has a lot of problems on the site, and now they're going to bring in a different use. So the question I have, it's a question, I'm not, is it, if it's allowed by right and nothing's changing except the interior of the space, does the site plan become irrelevant? Or is the matter of right a separate compartment, and the site plan becomes another place for a good and thorough review? Now, I can't answer your questions about how to pick and choose these things. I cannot answer that. I don't want to be a wise guy and say anything of that, or make it seem like, but it's the general piece that has this process been handled in a way that the ordinance anticipated it would be handled? And if it hasn't been, then I think it needs to go back. And if we think it has been, then it doesn't go back. And, in the past, we've been lucky. We don't have people coming to meetings with site plan reviews that are on napkins or on pieces of paper where we say, okay. But in this case, somebody has said, wait a minute, I think we need more information. And it's the applicant that the applicant has to conform with the ordinance. And if these things are deemed relevant, then we have to determine that they are. I'm not beating up on CSO. I didn't think they did anything wrong. Nothing about that. It's just, what is our process here?
But if this is an internal renovation to a building, and there's that activity doesn't spill out to the site, how do we send it back to them and say, even though that's the case, we want you to look at the project taking into account all of the site? What would they do? What would we direct them to do?
Let's say there was a junky piece of property in Greenfield that was causing all sorts of problems, and it had a use that was allowed. And somebody came and said, I want to switch the use. And the opinion was, you can switch the use because it's allowed. But that property is causing harm to everybody around it. And we all know that. Would we ignore that that's happening during the site plan review and just say, well, the use really is allowed by right, so therefore it's none of our business, the fact that we now have an opportunity to look at what's going on this property and make sure that if they're going to get this new use, they're also going to clear up some of the problems that exist on the site? If the answer to my question is no, that's not our role, then you're absolutely right. Then the site plan for this, which should be just an interior site plan, and that's all that's the sole jurisdiction, and that would be the end of it. But I want everybody to weigh in on this, because I don't.
To your example, if the yard is all junky and all, how much would we impose upon the appellant to fix up the property to make it acceptable to us?
Well, maybe we would.
No, but to what extent?
I don't know. That's case by case.
Resurface the building, put new roofs on, fix the lawn.
Fix the leak in the pipe, fix the pothole, fix the hole that nobody fixed 5 years ago. I mean, I don't know. I mean, what is the site plan for? Is the seminal question. What is it for? And so, I think maybe we've lost sight of what it's for. So it's become a routine. And if it's a routine, then that's what we want it to be, then that's where we go. But Yes.
Dave, it's an existing building. They're not gonna change anything outside the building. They're not going to overextend the parking, because people will be walking in, they won't have cars. Property's been there, they know what's going on with the walls, drainage, the parking, whole 9 yards, and we badly need this in our town. So I'm
Yeah, I
not
think
sure if you need
that-
a special permit or not.
I don't think the badly needs in our town is a factor. I think that's not, that might.
That's my opinion.
Okay, but I don't know what the factor is. So, okay, well, let's hear from Mark, Eric.
So I think I'm still just trying to kind of unpack, like, what is germane out of everything that we've heard? What are the primary questions in front of us? And I'm having a bit of a hard time wrapping my head around it, to be honest. I guess one of the questions that I have is kind of the level of notice that people are getting, or kind of like, was there an opportunity for abutters to come to that planning board meeting? Were people aware that that meeting was happening? Was there notification? Was there any conversation at that planning board meeting where concerns were heard? It seems to me like there's maybe that there's a piece of the process there that's kind of missing. Because in my experience, both sitting on this board and on planning board in the past, when people come forward during a site plan review or any public hearing and have concerns, the board then works to broker mutual agreement. Right? If there's privacy concerns, well, what can we do around screening? If there's noise concerns, what can we do around noise abatement? And that gets written into, well, I guess that is a little more of a special permit, but I think that it's still, even within site plan review, there is that opportunity to try to broker a little bit more agreement. So for me, what I'm confused about is, was that opportunity even present at this planning board meeting? Did people know that this was happening? Or was it just kind of on them to follow the calendar, know what's on the agenda? And
So the meeting was open to the public to comment. But the butters were not notified by any special means. So it was.
to me, that kind of feels like the issue here, and it feels like going back for site plan review remedies that issue, but it also seems if things were indeed done to the letter of the law, if the ordinance is followed, that the horse is out of the barn. So are we trying to then solve that problem after the fact?
I'm sorry.
Just to clarify for the board. By right, site plan reviews, most municipalities in the Commonwealth of Massachusetts do not require legal notices or butter notification. Greenfield never has, and it still doesn't. And so the planning board followed the process, and the Department of Planning and Development followed the process perfectly. The zoning ordinance can be amended, and if that's what people feel like needs to be done to address this issue for future applications, then let's change the ordinance. But the ordinance is what it is now, and it was followed exactly.
That's what I'm saying. I feel like that's where the problem lies.
Right, and that's, and had the ordinance been written differently and people been given an opportunity to be present at site plan review, we would not have, in theory, no one would be before us say, because that's the appeal is, I did not know this was happening. I wanted to be heard. This is my only recourse to be heard. So the question before us is, what do we?
Just one final statement,
Do we
Mr.
do
Chairman.
anything about that?
I mean, the city's calendar, meeting calendar, all meetings are posted, including site plan reviews and postings at City Hall here in this building. So if somebody's interested, I know you wouldn't have to make an effort, but if they were interested, they could find out exactly every single meeting happening for every land use board in the city, if they're interested. So that's opportunity is there. And if they do come to a meeting, the planning board is the most generous board in this entire city when it comes to allowing public input.
Stephanie, I'm not going to recognize you. I'm sorry.
Yeah, I mean, speaking as the average citizen in Greenfield, no one's looking at the site plan meeting, the planning board meeting schedule on an average basis. You might if you hear something might be going on, you might be looking for it. But if people going about their daily businesses, I mean, people who touch this every single day, it's something they're focused about. But if you're not that dialed in, it's not something you're thinking about. So, I can certainly understand the applicant's frustration, and not having known this was going on and would have spoken up at that point. So that's something we're gonna have to set aside for now, because that process was not in place. So what happens now?
And that's my point here. It's just kind of like even if everything was followed to the letter of the ordinance, it just feels, I don't think that it's reasonable that I would have to track every single public meeting that's happening to know if something is potentially happening next door to me that I want to have a voice in.
So are you saying that it should go back to the planning board?
I don't know. I recognize the problem in the current ordinance that helped to kind of create this, but I don't know that, we don't even have the jurisdiction to change ordinance, but I don't know that sending this back as a message that your ordinance needs, that the planning board or the city council needs to initiate an ordinance change, that's not ours to mandate, and it doesn't solve this specific issue. So it just feels like it's all kind of very thorny. If everything was followed to the letter of the ordinance, then why would we send this back? I don't think that the situation of being aggrieved would have hit this point had there been more notice and more communication at that point in time. But I don't know that sending it back is,
I mean,
I don't know that changes. It doesn't
Okay.
change the flaws in the ordinance that currently exist and led us to this situation. And I recognize that other towns might not have this in their ordinance, but they might not have had this problem come before them yet. So I don't think that needs to
I mean,
dictate whether or not we look at this, or if, the planning board or the city council looks at this for some future change.
yeah, like, I don't think there's anything we can do about that portion of it. It's just, so what is within our purview and our jurisdiction?
Yeah.
To deal with, to do now, because there's two parties of this. I mean, there's the applicant and there's the people who thought they were doing all of the right
Did what they
things
were
and
told to
moved
do.
along.
Yeah.
That's a factor. I think I start from this premise. We're the zoning board of appeals now. We're not the zoning board doing a special permit here. We're being asked, were the rules of our zoning ordinance followed properly? Yes or no? The fact that the applicant relied on whatever is a factor, and it may factor in as we continue to discuss this, but I just would like to ask that question. Aren't we the body that looks at what happened and decides whether it happened properly? If we feel that it happened properly, then that's the end of it. But if we don't feel like it happened properly, then it gets more confusing, because then the question is, well, what do we say the planning board should do? And what about the fact that the applicant relied on it? But those are problems we can talk about. But I would rather go that route and start talking about that than shut it down that somehow it's not our jurisdiction. I don't know. I feel like the stimulation from the applicant is based on flaws that we need to address, and I think we should make them right. I don't make any judgment on the merits except for the special permit part. I make no judgment on the merits of the site plan. And nor will I ever want to see that site plan, to tell the truth. So while it may be inconvenient, I think what happened with CSO was that they submitted their building plan. So they didn't have to do a site plan, or maybe they did a site plan through the building permit, but still. I just think that I want to stand up for the people in the neighborhood who I think deserve the chance to participate in a process that they were left out of, and whatever the reason was they were left out of it, they were left out. So if we want to say that it's tough luck that they were left out and we'll amend the zoning for later, then that's fine. But that's not where I sit. I think that our job is to make it right. The reason we're there, the reason this process is here is to make things right. It's the place. And so that's my sense of it.
Mr. Chair,
Yes.
can we just tease that out a little bit though, in terms of, so what we would do to make it right is kick this back to the planning board for a more thorough site plan review.
to have like a site plan with a locus map, and many of the things that are in here should be shown. Easements, we have a person here who's complaining about an easement. We have neighbors that are complaining that that the fences are on their property. We have people complaining that there are sinkholes next to their property. We have people complaining that stuff runs off the land into the road and floods it. We have like a dozen complaints about physical problems that exist at the property that the planning board could never have seen, would never have even been aware of to even comment. And if Stephanie went to that meeting and said, I have all these complaints, they wouldn't even have a reference frame from which to look. So I don't think that's fair. Now, again, I know that you relied on the planner and I get that, but I don't think that's not where I begin. Might be where I end, but it's not where I begin.
So to be clear though, so what, in your eyes, what would be more fair is creating the opportunity for the planning board and the community to have that conversation. And the outcome is just going to be whatever the planning board decides.
And they get.
That doesn't mean that anything's going to be different. It just means that the process is going to be teased out, more public, more information. But I guess I'm just kind of,
Somebody's gonna have to give the applicant and the neighbors an explanation for why it's okay for the water to run off or for the pothole to be there, for whatever the things are. They may be not even be there, I don't know, but there's enough allegations that it feels like, and I heard from the counselor for precinct 6. It's not like it's a single person. There's a lot of discomfort in that neighborhood. And yes, I do think the zoning needs to be changed, but that's for another day. So,
Well, didn't you say not that the zoning needs to be changed, but that the planning process needs to be amended?
well, and maybe people need to be given notice. Let's start with that.
The only way that can change is by changing. the ordinance.
that
Yeah.
process.
That
is
would be-
not that
Which would kick it
Which
back
would
to
start from the planning
city
board
council.
and go to the city council,
May I comment?
please.
I'm new to the board, so these are all new issues for me, so hope you guys will bear with me.
This is new for us too.
Yeah, well, okay.
So it would be good to hear your thoughts.
I feel this is, quote David, this is another case of Solomon cutting the baby in half. That we've got, on the one hand, we've got an organization that wants to do something that I believe is really good for the town, for the city of Greenfield, and that we definitely need. And that issue is, to me, there's no question at all. On the other hand, we've got complaints coming from the neighbors about things that sound like these are real issues for them. These are things that affect them, that got, water running into their basement, for God's sakes. This is real stuff. That's not easy stuff to deal with. But what I don't see is, I don't see where in the zoning board of appeals process where it's our job to deal with that. Right now, maybe it should be, maybe it shouldn't be, I don't know, but right now it's not there.
No, we don't have to
We're
deal with
responsible.
it. We don't have to deal with the
Yeah.
specifics. We just have to decide whether getting here followed the process according to the zoning ordinance.
And I don't think there's much question that in fact, the legal process, as strictly defined legal process, was followed. And it also seems to me that, the conditions that were explained by Attorney Quinn in his letter to us make it pretty clear what our role is here too. As far as the zoning part of this goes. So, I'm horribly divided on this. It's a really tough one. I mean, I want to satisfy both sides of this. And I know there's no way to do that. So, I don't get a vote, so I don't have to tell you what I feel about it.
Well, no, we appreciate hearing what you have, what
Yeah,
your thoughts
thank
are.
you.
No, it helps.
I hope what I said.
So do have you changed any of your sensibilities of this based on our conversation, or you haven't?
I mean, I'm completely empathetic to the people, don't get me wrong. I mean, I see all the issues, I see the problems. It'd be nice if we could accommodate that and resolve it, but I don't see that changing my opinion as the process that we're here to validate. So, again, I'm not, again, I wish all those things, just like you say, I wish they would all be resolved, but they can't happen, or can't happen easily, I should say. Well,
Okay,
Is a question, is the timeline for CSO such that it would not, in fact, not allow going back to the planning board, and that it would disrupt the timeline for getting the construction back?
Be very disruptive to the construction of the wells. Sorry. At least.
okay.
There,
All right, thank you. All right, so let's make some motions. Let's do two motions, one around the special permit. And then one around the site plan.
Before we move on, though, I want to tease out your thinking a little more about the very notion of sending it back, because I guess if we're all saying that we're in agreement and have been advised that legally this was indeed by right proper, then how do we send it back? Period. How do we have the right to kind of say, like, no, this doesn't require a special permit, but we are kicking it back to planning board for a site plan review? Where do we even get to do that if we
So
wanted
the
to?
statute says that we are a board of appeals that gets to decide whether the building permit was properly issued. So we could form an opinion that the building permit can't be issued without another site plan review, because we believe that the site plan review was deficient. Now, I could see from the conversation that there's not gonna be 4 votes for the site plan to go back to the planning board. So it's a nice conversation. And we've tried hard to talk to each other and see where it's at, but I think it's, we're beating the horse a little bit here. I mean, if Peter and Jim were to say, tell me something else, or I still have questions, but if not, then that's fine. Then that's where we're gonna go. I mean, I'm not trying to leave you out of it, but if there's 2 votes against it, then maybe you're gonna vote against it too. But I know if there's 2 votes against it, that's it's not gonna work.
I mean, my opinion is that there's been enough there've been enough people coming forward to have me question whether the site plan review was done thoroughly enough. Without, I think they were lacking in information that might have had them make different choices or different decisions, or at least ask more questions. Maybe the answer would be the same. But I don't think, as far as the way everything is written, I don't think anything was done improperly. Which is hard for me to say, when I am empathetic to what everyone has to say, what everyone feels. And is thinking I understand all the frustrations, but when the laws are written and and everyone does follow them, it's hard for me to then go back and say, sorry, you were wrong, just follow the law.
Do you think they followed the section 8.4?
I think they did. I think if they did, I guess my 2 cents is the planning board should have made sure that
They did.
everything that was presented, that they had everything they needed to make the decision. If they determined they did, I don't think it's my job to go through and check off that, yes, to double check their work.
Okay. Fair enough. Anybody else? Okay, so would somebody make a motion on the issue of by right or by special permit? So we move, Gordon, can we do a normal motion like we would do for any other meeting? So we move to adjudicate that in the portion of the appeal that relates to whether or not the property requires a special permit or not. The board's decision is that it does not require a special permit for the following reasons. One, it's a educational nonprofit that follows the requirements under the so-called Dover Amendment, Section 48, Section 3, and the case law that we reviewed. Number 2, if relevant, it's allowed by right under Section 207.10, if applicable. So there's a belt and suspenders here and maybe another suspenders. Then the third is, which I hadn't thought of, but I saw in the memos from Eric, that it also complies with the section, I don't know the site of the section, Eric, maybe you can just fill that in when we, the section, it's the section on professional and professional office use.
And isn't it like 200.4.7B?
Sure, what is it?
I think it's this one here that lists what falls under central commercial.
Exactly.
Yeah, it's 200.4.7B.
So under any or all of those, the use that they're asking for is allowed by any or all of those reasons. So I need a second.
I'll second that.
Okay. Is there any discussion? Okay, all in favor? Okay, so the panel is announced. The panel that's.
Peter Wozniak.
Jim Wynn?
Mark Maloney.
Debbie Jones.
David Singer. Okay. So all is in favor. Well, let's go around. Peter, you say
Aye to the.
to that, to the motion.
To the motion.
Aye.
Aye.
Aye. So let it be shown that it's unanimous. I don't want to make the next motion.
So, I mean, the motion, I guess, yeah, the motion before us is it, you know, is that it's the board's opinion that due process was,
Make it easier, like the
Yeah.
board's decision that the requirements of the zoning ordinance under site plan review were followed. Were followed
followed,
properly.
followed.
Anybody?
I'll second that. Or
Make
or do I
a
second?
motion. You'll second it?
Yes.
Any discussion?
I didn't read it.
All right, same panel.
Aye, Peter Wozniak.
Yeah.
Aye.
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 No. Okay, is there any other business that we need to talk about?
We don't have any minutes.
Yeah, before we leave, just before, a final thing, before we leave this. I would ask CSO to work with the neighbors to resolve these issues, not to stonewall them, but to deal with the stuff that has been raised here. There have been obviously valid concerns raised about a number of issues to do with the water and parking and access to the building and so on and so forth. That we can't legally force you to do this, but you have to be neighbors. You know, we live in a small city and getting along with your neighbors is something that I believe is a really important part of being a good citizen, a corporate good citizen. So I appeal to you to reach out to them, to listen to what their concerns are and to work with them, get involved with.
Anybody else want to say anything? Yes.
Well, I just am wondering, is it possible for the ZBA to create, not this moment, but could we create some kind of documentation or letter for the planning board, for the city council, for the mayor's office, outlining this experience and maybe asking that somebody consider doing some modifications to the zoning ordinance?
Oh,
Just to let you know as a board, I know it hasn't really happened much in the 17 years I've been here, but 5 entities can propose a zoning amendment. You have the equal right as the planning board to initiate a zoning amendment.
Oh, I didn't realize that the ZBA could.
Yes,
but it still has to go to the planning.
for a recommendation.
But I mean,
So a city council,
do something to try to circumvent this and take a better look at the zoning ordinance and look at, even by right, can there be some level of butter notification so that it's not, the burden's not on every single one of us to pay attention to every single open meeting that's happened to figure out if there's an impact on
And
us.
give people the opportunity to say something at the. at
Feels
that
like it could be stronger in terms of notification, which would have circumvented, I think, a fair amount of this from the jump. So if we can initiate something like that, again, it doesn't have to be right now at this meeting. I'd love to have that conversation on the agenda and start teasing out.
Can we have a meeting where we discuss that kind of stuff?
oh, sure.
Okay, so then we'll put it on the agenda.
And one other thing, Eric, if we have that meeting, is to put in some kind of format or some recommendation to an appellant that, to Dave's point, if there's going to be a site plan review, you, the appellant, have to follow, you know, the stuff that's in section 8.4. So, because we've seen a lot of them where they literally check off, check one by one. They check it off, not applicable. I think that for applicants, so it doesn't put a burden on you, but to say they have to adhere to these to show us why this may not be applicable, or if it is, how they resolve it.
Yeah.
All of the ones that we saw for the marijuana ones had those documents submitted. And maybe that's because the CCC asked for it, but I think we should do the same for other applicants.
Yeah.
So they show all these things being checked off.
I'll make a motion, meeting to adjourn.
Second, all in favor, say aye.
Aye.
Any opposed? Okay, thank you, everybody.